application in the matter of the King of the applications of Hippolyte and Secretary of State for the Home Department.
Yes, Mr Butler.
My lord, my lady, I appear with Miss Brown, the appellant,
Yes.
my learned friend, Mr Brown, King's Counsel for the Secretary of State.
Yes. Before we go further, we perhaps need to clarify there's a reporting restrictions order which we extended till this morning. So far as we're concerned, it ought to carry on, but I don't know whether either of the parties wish to have it varied or whether there's any member of the press here today who wishes to make any application.
I don't seek anything additional. I'm not aware of any members of the press.
No, I can't see anybody who looks as well. No, well, we'll continue that order. Good. The second thing is that the three of us have read the additional evidence that has been put in. I can't use the phrase de bene esse, but that's what we've done. And if anyone needs to refer to it, then we'll have to evaluate where it sits. But I hope you're comfortable with that. It seemed to us to be the sensible thing to do.
I am comfortable with that. Could I just make two very short points on that application? The material was available to the Secretary of State in advance of the High Court hearing, and no good reason has been given for not having disclosed it then, so we say. And as my learned friend says at paragraph 24 of the Secretary of State's skeleton argument, it's unlikely, even on the Secretary of State's case, to have any material impact on the appeal. And in those circumstances, we respectively say that the Ladden-Marshall criteria aren't satisfied, and it shouldn't be admitted on this appeal. But I don't press the point very forcefully. That's
it falls into an odd category, because it's not being admitted to be relied upon by the Secretary of State, particularly. It's just being admitted because it had been left out for completeness.
Yes, and it is said, you may not necessarily accept this, but it is said for the respondent that it's to comply with their duty of candour to assist the court.
Yes.
And speaking for myself, I would be loath to do anything which discouraged respondents from continuing to comply with the duty of candour. It's not unheard of that things are shown to us in the Court of Appeal that have not been shown to the High Court because of candour.
Yes. Well, my Lord, I'd respectfully agree with that sentiment. And in circumstances where the Secretary of State doesn't seek to derive an advantage from the new material, I entirely accept that it's been put before the court properly in accordance with that duty.
Yes. Good. Thank you. Then the only other matter is whether the two of you have considered what order you wish to use the time and address the court.
We have, my Lord, and subject to the court's views, we were proposing that I go first and deal with both the respondent's notice and the appellant's notice. And I would have up to lunchtime. I may not need all of that. And then my learned friend goes from lunch from 2 o'clock until about 3:45, with me having up to half an hour in reply.
Well, I think we're entirely in your hands. That's the sensible way to proceed.
Thank you. I hope the court has received 2 additional authorities from me.
I certainly have. They were added overnight.
They are paginated to slot in at the end of the authorities bundle and as a replacement index.
And in addition, the three of us have all read the case of Greenfield, which I think we've circulated to you. But
yes, thank you.
I haven't got a physical copy of it, as I said here, but I don't. If either of you were to refer to it, then we can arrange the copies.
Thank you very much.
Another day.
So, unless there are any other preliminary matters, my Lord.
I think not.
The Secretary of State's Windrush policy identifies certain circumstances in which she will grant ILR, indefinite leave to remain, outside the immigration rules. Under the policy, the child of a Windrush migrant will be granted ILR if they satisfy certain criteria, including that they've remained in the UK since they arrived. The judge identified that requirement as being a proxy for satisfying the Secretary of State that the child had a strong and subsisting connection to the UK. The appellant satisfied the Windrush criteria except for that continuous residence requirement, and she asked the Secretary of State to waive that criteria. As I propose to show the court, immigration rules can't be waived, but criteria that guide the exercise of the broad discretion to grant leave outside the immigration rules can be waived. The judge found that the Secretary of State refused to consider waiving the criterion, and that this constituted a fettering of her statutory discretion. By a respondent's notice, the Secretary of State challenges that conclusion. She contends that the appellant's request to relax the Windrush policy requirements could only validly have been made in this case using the form for Appendix FM to the immigration rules, and that the appellant's request was therefore invalid. Alternatively, she contends that she did consider exercising her discretion to waive the continuous residence criterion, but made a reasoned decision not to do so. Having found that the Secretary of State didn't consider exercising her discretion to waive the continuous residence requirement, the judge nevertheless dismissed the claim because he concluded that it was highly likely that the Secretary of State would have exercised her discretion so as to refuse ILR. We say that in doing so, the judge trespassed into the forbidden territory. The discretion belongs to the Secretary of State. It was never exercised. There's no evidence to indicate how it might be exercised. It wasn't, in my respectful submission for the court, to attempt to predict how the Secretary of State might exercise the discretion. With that said, by way of introduction, could I please give you the outline structure of my proposed submissions? 6 headings. First, the statutory basis for the immigration rules and the Secretary of State's power to grant leave outside the immigration rules. Second, the way in which the non-fettering principle applies to policies relating to the power to grant leave outside the immigration rules. Third, the Windrush policy. Fourth, the request to waive the continuous residence requirement and the Secretary of State's response. Fifth, the Secretary of State's submission on this appeal that a request to waive a requirement of the Windrush policy had to be made using a form under the immigration rules. And sixth, whether the judge erred on the section 31(2)A question.
Yes.
So if I may, topic 1, the Secretary of State's discretion to grant leave. The Secretary of State has a very wide discretion to grant leave to remain to non-British citizens, and one sees that in the authorities bundle at tab 1, section 3 of the Immigration Act 1971, subsection 1b. If the Secretary of State is going to make concrete rules on how that discretion is to be exercised, then those rules have to be laid before Parliament. And one sees that on the next page at section 3, subsection 2.
Yes.
So one sees that the statement has to be laid before Parliament and is subject to the negative resolution procedure. Could I then please ask the Court to look at tab 15 of the authorities bundle, which is the Supreme Court's judgment in Alvey. In that case, the Secretary of State had laid a statement of changes to the immigration rules before Parliament, which established a points-based system for skilled migrants. and it provided that no points would be awarded unless the proposed job appeared on the department's list of skilled occupations. The department then published a list of skilled occupations on its website, but didn't lay that list before Parliament. And the Supreme Court held that this was unlawful because any criteria that might be determinative of an application for leave had to be included in the immigration rules. And one sees that at page 539 at paragraph 57 of Lord Hope's judgment. And as one sees, Lord Hope agreed with what Lord Dyson said at paragraph 94. One finds that at page 548. If the court could please read paragraph 94 of Lord Dyson's judgment. At the same time as hearing the case of Alvey, the Supreme Court heard a case called Munir, and the judgment in that case is at tab 4 of the authorities. In this case, the Secretary of State had published and then withdrawn a policy that made more generous provision than the immigration rules. And as we'll see, the policy was called DP 596. The claimant argued that the withdrawal of the policy was unlawful because it should have formed part of the immigration rules in the first place, and its withdrawal therefore also needed parliamentary approval. The Supreme Court held that it was permissible to promulgate a policy outside the immigration rules without parliamentary approval, providing that it didn't specify rules that were determinative of leave. And it followed that the withdrawal of this concessionary policy also didn't require parliamentary approval. Could I please show you the court's reasoning on that? It's page 37. And at paragraph 44 of Lord Dyson's judgment, he said, in my view, it's the 1971 Act itself which is the source of the Secretary of State's power to grant leave to enter or remain outside the immigration rules. The Secretary of State's given a wide discretion under sections 3, 3A, 3B and 3C to control the grant and refusal of leave to enter or to remain. The language of these provisions, especially section 3.1b and 3.1c, couldn't be wider. They provide clearly and without qualification that where a person isn't a British citizen, he may be given leave to enter or remain or indefinite leave to enter or remain in the UK. They authorise the Secretary of State to grant leave to enter or remain even where leave wouldn't be given under the immigration rules. And if I could ask the court, so one sees their broad statutory discretion, if you could then please also read paragraphs 45 and 46. So it's fine for the Secretary of State to promulgate inflexible rules that have to be satisfied before a migrant will be given leave. But if the Secretary of State is going to promulgate inflexible rules, they have to be laid before Parliament under Section 3, subsection 2 of the Immigration Act. It's also permissible for the Secretary of State to promulgate flexible policies on how she's going to exercise her broad discretion outside the immigration rules, but those policies can't contain inflexible rules. Given that the immigration rules are a special kind of policy that is formal and prescriptive, the non-fettering principle doesn't apply to the immigration rules. By contrast, in my submission, it does apply to the exercise of discretion outside the immigration rules. And the Court of Appeal explained this in the case that's behind new tab 16. This is a case called AB, and it was about the requirement in the immigration rules that an asylum applicant had to be in the UK at the date of determination of the claim. If we could look, please, at page 570. Could I please ask the Court to read paragraph 45 of Lord Justice Legate's judgment? The inapplicability of the non-fettering principle to the immigration rules is why, for the purposes of the immigration rules, a miss is as good as a mile. But that doesn't apply to the discretion to grant leave outside the immigration rules, because that is an unfettered discretion. The discretion, I should say, the discretion to grant leave outside the rules in AB didn't help the claimant in that case, because he hadn't asked the Secretary of State to consider his claim for asylum outside the immigration rules. And one sees that in the first sentence of paragraph 47. Could I then please turn to my second topic? How does the non-fettering principle of policies relating to leave outside the immigration rules? Now, in my submission, there's a tension in public law decision-making between two imperatives. On one hand, the need for administrative efficiency and consistency of approach, which is needed when decisions are taken by caseworkers rather than by the Secretary of State herself. On the other hand, there's the need for flexibility to avoid fettering the broad discretion entrusted to the Secretary of State by Parliament, and to ensure individualised justice. And in my submission, those competing imperatives are reconciled by the public law principles that a decision maker may publish a policy so that her caseworkers exercise her discretion on her behalf in a consistent way. But her caseworkers must always be willing to depart from the policy if the circumstances of an individual case warrant it.
Well, they must be willing to consider someone. That's the fundamental principle, isn't it, in British Oxygen?
Yes.
Lord Reid there said that you can have a policy which is, for practical purposes, tantamount to a rule. But what you can't do is close your ears
Yes.
and say never.
Yes, yes, I accept that. what I was going to show the court is, in my submission, a convenient encapsulation of the principle from Lord Kerr's judgment in the case of Lumber, which we've got at tab 5 of the authorities. As I say, this is Lord Kerr's concurring judgment. And if we could look, please, at page 116. If the court would please read paragraph 245. Now, the non-fettering principle doesn't require flexibility to be written into the policy. It's permissible for the policy to be framed in hard-edged terms, but an apparently hard-edged policy must still be applied flexibly in accordance with the non-fettering principle. And one sees that explained by the Court of Appeal in the West Berkshire case that the judge referred to below. This is at tab 7 of the authorities. It was a case about national planning policy. If we could please look at page 191. If the court wouldn't mind reading paragraphs 16 and 17. And then for completeness, could I ask you please also to look at page 193 and paragraph 21. Could I then please provide an example of how those principles have been applied in the immigration context by reference to the case of KA, which is at tab 12. The case concerns the Afghan national dependents of British citizens who sought entry clearance to come to the UK from Afghanistan. By regulations, the Secretary of State has a statutory discretion as to whether to require a person seeking entry clearance to provide biometric data as part of their application. In the Afghan context, the Secretary of State promulgated a policy which stated that she would always require Afghan dependents to provide biometric data. The court summary of the policy, if I could show you that, begins at page 392. And one sees at letter C, the heading of this section, ARIP, that is the Afghan Resettlement and Immigration Policy Statement. And the relevant passage of the policy is set out at page 394. At letter C, where it says the UK is working with international partners to secure safe routes out of Afghanistan as soon as they become available, but while the security situation remains extremely volatile, we recommend people in Afghanistan don't make applications and pay application fees at this time, as they will not be considered until biometrics are provided. Those Afghans who are outside of Afghanistan are able to get to a visa application centre to provide their biometrics are able to make an application in the usual way. Now, as that suggested, it was impossible for people in Afghanistan to provide biometrics at that time because there was no visa application centre, and one sees that confirmed at page 382, paragraph 8, first sentence. The claimant's wife and children in that case were stuck in Afghanistan. The claimant challenged the refusal to consider their applications for entry clearance in the absence of biometrics. At the hearing of the claim, the Secretary of State stated that the non-fettering principle meant that the policy statement had to be read as being subject to the Secretary of State always being willing to consider waiving the biometric information requirement in an individual case. And one sees that recorded at page 402. If the court would just read paragraph 90, please. And then if the court would also please look on the following page at paragraph 97. And that, in my submission, is an illustration of how the non-fettering principle applies to an apparently hard-edged provision in a policy that isn't part of the immigration rules. Could I then please turn to my third topic, the policy in our case? The Windrush Scheme is in the supplementary bundle at page 222. So this is the policy document, and my learned friend has also provided the court with a caseworker guidance on the scheme. Could I begin, please, with the legal status of this document? It doesn't form part of the immigration rules, and it hasn't been laid before Parliament. Rather, it provides for the grant of leave outside the immigration rules. It identifies certain circumstances which fall entirely outside the categories of the immigration rules, in which the Secretary of State says she will nevertheless ordinarily exercise her discretion to grant leave under section 3(1)(b) of the Immigration Act. It doesn't say that, but that's the legal effect of the policy. And the judge in my submission correctly identified this. If we could please turn up his judgment in the core bundle. At page 83. Paragraph 14, first three lines, the policy set out in the Windrush Scheme document doesn't form part of the immigration rules, rather it's a concessionary policy of the Secretary of State in exercise of her discretion under section 3(1)(b) of the 1971 Act. If we could then please look at the applicable provisions of the scheme by reference to the judgment, this begins at core bundle page 81. There is a heading just above paragraph 8, the Windrush Scheme. And at paragraphs 8 through to 10, the judge explained the Secretary of State's reasons for promulgating the policy, which was in response to the injustices suffered by the Windrush generation. Then overleaf, still part of paragraph 10, the judge identified the 4 categories in which the policy document states that the Secretary of State would exercise her discretion to grant leave. We're concerned with the 4th of those categories, if the court wouldn't mind rereading that 4th category. And so one sees that there are 5 elements to it. First, the person has to be in the UK. Second, the person has to be the child of a Commonwealth citizen parent. Third, the person had to have been born in the UK or arrived in the UK before the age of 18. Fourth, the person has to have been continuously resident in the UK since birth or arrival. And fifth, the parent had to have been settled or had the right of abode before the 1st of January 1973. Now, if I may make 3 points about this. The first point is that although the trigger for the policy was the historic injustice to the Windrush generation, Category 4 didn't require there to have been any historic injustice in the individual case. The only Windrush connection in Category 4 is the Commonwealth parent who settled during the Windrush era. Second, on the judge's analysis, the continuous residence requirement wasn't an end in itself. Rather, it was a proxy for the child having strong and subsisting ties to the UK. And one sees that in the judgment at page 98. If the court would please read the first sentence of paragraph 72.
Sorry, paragraph
72.
72.
And I don't understand the Secretary of State to have sought to challenge that conclusion in her respondent's notice. My third point about Category 4 is that given that this is a policy outside the immigration rules, the continuous residence requirement isn't an inflexible rule. The Secretary of State must be willing to consider relaxing it in an appropriate case. For example, if she was satisfied that sufficiently strong and subsisting ties with the UK could be established in another way, she might decide to exercise her discretion to waive that requirement. If the Secretary of State wanted to harden the policy into rules, she would need to make them part of the immigration rules and lay them before Parliament under Section 3, subsection 2 of the Immigration Act. Can I then please turn to my fourth topic, the request to waive the continuous residence requirement and the Secretary of State's response? Could we begin, please, with the review decision, which is in the same bundle, core bundle, page 198. This is dated the 20th of April 2023, it's the final stage of the decision-making process under the scheme. And halfway down the page, there is a heading, Reasons Why Your Review Has Been Refused. And the second paragraph reads, You asked me to consider the following new evidence. And the second bullet point under that refers to the appellant's evidence that she had strong ties to the UK. And then overleaf, after the bullet points, the next paragraph reads, I've looked at this carefully. However, this doesn't change the original decision to refuse your Windrush Scheme application because none of the points you've raised demonstrate you meet the requirements of the scheme. Now, of course, the reason these points were raised was presumably to try to persuade the Secretary of State to exercise her broad discretion despite the requirement not being met. The next paragraph then recites the fourth category of the scheme, and then the paragraph after that reads, your Windrush application was refused on the basis that, as you'd left the UK between 2003 and 2006, that you hadn't been continuously resident in the UK since you arrived age 17, this is still considered to be the case. So this letter, in my submission, treated the continuous residence requirement as a rule. The appellant couldn't satisfy the rule, and the Secretary of State was, for that reason, refusing to grant the appellant leave in the exercise of her powers under Section 3(1)(b) of the Immigration Act. The appellant solicitors responded to this with a pre-action letter, which is, I'm afraid, in the supplementary bundle at page 130. This letter advanced three suggestions. The first of those begins at the bottom of page 142. At the very bottom of that page, one sees the heading Indefinite Leave to Remain. And this was a submission that the Secretary of State should have recognised, so it was said, that the appellant would have been able to settle in the UK in 2002 if the Home Office had provided her father with proof of his right to remain in the UK. Nothing in this appeal turns on that submission. Second, page 147. The last heading on that page is headed Error in failing to consider whether to exercise discretion. If the court would please read paragraph 46. Is, of course, this section of the letter that we say is relevant to the appeal. And then overleaf paragraph 50, the letter identified 4 factors that it was said the Secretary of State should have taken into account when deciding whether to relax the continuous residence requirement. A and B covered similar grounds to the first submission, that the appellant was unfairly denied the chance to obtain leave in 2002. Point C is important. This was the submission that the appellant had strong ties to the UK and compelling compassionate circumstances. And then point D concerned the best interests of the appellant's children. On the following page, could I ask the court please to read paragraph 51?
In the third line, perhaps it was an unfortunate phrase to use, to leave to remain under the Windrush Scheme.
Yes.
And actually, in substance, what I think was being asked
Outside.
for was an exception.
Yes. Yes. It's not well worded, but in my submission, if one reads the whole of that section fairly, that's what it's asking for.
I see.
There was then a third submission, which begins on page 149 under the heading, "The claimant is a returning resident." And the contention here was that the appellant should have been treated as being entitled to return under paragraph 19 of the immigration rules. As with the first submission, nothing in this appeal turns on that contention. Could I then please show the court the Secretary of State's response to this letter, which is back in the core bundle at page 202. This is a letter dated the 25th of May 2023. And if we could look, please, at page 204, under the heading Response to the Matters Raised, the Secretary of State rejected the appellant's first argument, what she called ground one, the contention that the Secretary of State should have recognised that the appellant would have been able to settle in the UK in 2002 if the Home Office had provided her father with proof of his right to remain in the UK. As I've said, I don't challenge that conclusion. Then page 205, the letter addressed the appellant's second argument, the contention that the Secretary of State had failed to consider exercising her discretion to waive the continuous residence requirement. One sees under that heading, throughout your PAP letter, you refer to the Secretary of State's ability to apply discretion to applications and question why this wasn't utilised in your client's case. The Windrush Scheme, which came into force in May 2018, allows for a grant of ILR to be made in cases where the child of a Commonwealth citizen who was settled prior to the 1st of January 1973, and then it goes on to say, in effect, satisfies the specified requirements, which are then recited. Following paragraph, the introduction of the Windrush Scheme in 2018 represented a conscious choice to ensure that a specific cohort of people could more easily acquire ILR. As explained in previous correspondence, your client doesn't fall within this cohort. The decision of the 20th of April 2023 states, and in effect, that the appellant didn't satisfy the returning resident criteria, the third argument. And then it says this: the decision letter also lists the representations made by your client that were taken into consideration on pages 1 and 2. Therefore, your client's representations were acknowledged and considered. However, discretion wasn't considered appropriate to apply as mandatory requirements haven't been met.
So that's the passage the judge particularly, amongst others,
Yes.
particularly latches onto.
Yes.
As it's a statement of computer says no, we've looked at it again, computer says no.
Yes.
And there's-
In my submission, the word "as" is a cause.
The word "as" is ridiculous, because discretion was not considered appropriate because the mandatory requirements are not there. It's
Yes.
just wrong.
Yes. I was just going to make
Contradiction in terms.
the obvious linguistic point that "as" is a causal conjunction.
Yeah.
The Secretary of State was refused, as my lady says, the Secretary of State was refusing to exercise her statutory discretion because the requirements of the scheme hadn't been met.
Yeah.
Those requirements were, as she put it, mandatory.
Yeah.
And as a result, the Secretary of State hadn't considered whether the appellant could demonstrate a sufficiently strong and subsisting connection to the UK in other ways.
Well, the only way to make sense of it, Mr Butler, is to say that discretion is being used in that context, in a very narrow sense of meaning a discretion under the Windrush Scheme, which is the type of departure from the immigration rules that the Windrush Scheme was dealing with.
Yes, in effect saying...
But it's not saying a discretion outside the Windrush.
No, well, no, but in my submission, the Windrush Scheme is simply a set of guiding principles to help the Secretary of State apply her broad statutory discretion outside the immigration rules. What it can't do is to impose hard-edged requirements, because if one imposes hard-edged mandatory requirements, one is making rules. And so, as we read that paragraph of that letter, from the Secretary of State's perspective, the policy criteria were being treated as rules, and a miss was as good as a mile. Now, as I sought to show the court by reference to LV, Munir, and AB, that's the proper approach to the immigration rules. But in relation to a policy outside the immigration rules, this, in my submission, constituted a fettering of discretion.
You could also pray in the previous letter. I mean, I noticed that towards the end of the previous letter, there was a passage which said, of course, you can always apply under some other route. I think that reinforces it.
Yes. Well, although the previous letter wasn't responding to an express request for the exercise of discretion, that was the implication of the request to consider that material, because it could only conceivably be relevant to a departure from the requirements of the Windrush Scheme. But as my lady says, the response to that was, well, this doesn't help us because it doesn't fall within the requirements of the scheme. Could I also please show the court the Secretary of State's pleaded case in the High Court, which is in the core bundle, same bundle, at page 137. I should say immediately that these weren't pleaded by my learned friend. Counsel, the Secretary of State was differently represented in the High Court.
Yes.
If the court could please look at the following page, page 138, and read paragraph 4 of the amended detailed grounds of defence. And in a nutshell, that reiterated the Secretary of State's then position that the requirements of the Windrush Scheme operate as hard-edged rules. Could I then please show you the judge's conclusions on this point in the core bundle, same bundle, page 87. From paragraph 28 onwards, one sees the judge's assessment of the fettering arguments. The key passages begin at page 89. If the court would reread or just note paragraph 34. And then if I could also draw particular attention on page 90 to paragraphs 36 through to the end of 38. Where the Secretary of State is dealing with the letter we've just looked at. Sorry, the judge is looking at the letter we've just looked And then the judge considered the broader context at paragraphs 39 through to 49, which led him to the conclusion which one sees at page 93, paragraph 50. And we respectfully submit that that conclusion was correct. The Secretary of State had erred in treating the continuous residence requirement as a rule rather than guidance, and had failed to consider whether to exercise her section 3(1)(b) discretion by reference to the particular circumstances of the appellant's case being put before her. Could I then please turn to my topic 5, which is the Secretary of State's contention that a request for her to exercise her discretion has to be made on form Appendix FM. If we could please look for a moment at the Secretary of State's skeleton argument in this appeal. At paragraphs 15 and 16, at paragraph 15, the Secretary of State contends that the applicable guidance is the compassionate circumstances policy, and 4 paragraphs of that are then set out. And then at paragraph 16, the Secretary of State contends that if the appellant had wanted the Secretary of State to exercise her discretion to grant leave outside the rules, she should have used form Appendix FM and should have paid the fees for such an application, which I note are currently set at £3,029, and for which no fee waiver is available because it's ILR.
3,000 and how much?
3,029, that's the current figure.
So what's wrong with the Secretary of State's fundamental contention that if you want them to exercise their discretion outside the rules, you should pay the appropriate fee?
Well, the fee that I've just identified, the £3,029 fee, is the fee for an application under the immigration rules.
Right.
That's what you have to pay if you're making an application under Appendix FM, using form Appendix FM. I can show the court if you want to see the passage, but one of the points made by the Windrush Scheme is that you don't have to pay a fee for applying under the Windrush Scheme.
Right.
Now, I wanted to make, if I may, 3 points about this submission by the Secretary of State. The first relates to what the compassionate circumstances policy says. We've got this in the supplementary bundle at page 230.
Mine stops 229.
Mine does too, I think.
I've got a second set of bundles. Stops, yeah, 242. You got that?
Yeah.
Yeah.
Thank you. So, one sees that the short title to the document is Leave Outside the Immigration Rules. But in my submission, that's a confusing title because there are other guidance documents that also guide caseworkers on how to exercise the Secretary of State's discretion to grant leave outside the rules. It's the long title that makes it clear that this guidance is focused on certain kinds of request to leave outside the rules, those based on compelling compassionate grounds. And that's reiterated at page 232 in the first paragraph under the heading about this guidance. Then the second paragraph explains that there are other guidance documents addressing leave outside the rules, including last 7 words where there is an existing public concession. And the Windrush scheme, in my submission, is such a concession.
Sorry, there's the second paragraph. Yeah.
Last 7 words on the second paragraph. Could we then please look at page 238? Top of that page, there's the heading process. There's then a heading further down, applying in the UK for leave outside the rules. And it's that section that, as I showed the court, is cited in the Secretary of State's skeleton argument. The first sentence provides that one should use the application form for the route that most closely matches one's circumstances. And as I'll show the court in a moment, there is a Windrush Scheme form, and that, in my submission, is the one that most closely matched the appellant's circumstances, and that's what she used to make her application. Then the second paragraph, if you want to be considered solely for leave outside the rules, then you should use form FLRHRO. And over leave, first paragraph on that page, if you want to be considered for ILR outside the immigration rules, you should use form SETO. Top of page 239. Now, the Secretary of State didn't make any submissions about this in the High Court, but she now says through her respondent's notice that this guidance means that the appellant should have used the form for Appendix FM to the immigration rules. But in my submission, that can't be right, because the appellant was asking for ILR entirely outside the immigration rules. And this document says that if you want ILR outside the rules, then you should use form SETO, top of page 239. But it's also not the case, in my submission, that form SETO has to be used for every application for ILR outside the rules, because leave for a Category 4 person under the Windrush scheme is ILR outside the immigration rules. And the Windrush scheme says that you have to apply using the Windrush application form. One sees that in the same bundle at page 222.
And it's right, is it, that the Windrush scheme does not require the payment of any fee or charge?
One of the requirements, well, I can show the court that rather than me make submissions on it. Page 222, to answer my Lord's question, towards the bottom of that page there's a heading application fee.
Right. There is no fee.
There is no fee.
Yeah.
And immediately above that, how to apply, an application under the Windrush scheme must be made on the relevant form, and the form is called the Windrush Scheme Application, UK.
You accept that your client does not fall within the Windrush scheme, paragraph 4, because she can't show continuous residence, and so her application has to be considered under discretion.
Well, the Windrush scheme is discretion.
So is it the case that you're saying that your client used the correct form, because that's the one closest to her circumstances, and it's within the Windrush scheme? If she isn't actually within the Windrush scheme but wants discretion, does she have to file a second form?
Well, can I show?
Or do we get there having found that she's failed to come within Windrush, then that triggers anyway?
Yes. So
discretionary process.
Yes. The two options seem to be the Windrush form, or if one looks at the compassionate circumstances policy, form SETO. How does one reconcile that? Which form should one use? Well, in my submission, the answer is found in the passage we've already looked at, which is page 238.
Well, that's what the government's policy says. But I'm concerned, speaking for myself only, about a much more fundamental point of principle, which is it open to the government in public law to say, when you're asking for an exception to be considered as per British Oxygen, you have to use a prescribed form and have to pay for that? Or does British Oxygen say, when you ask for exceptional consideration to be given, that's precisely what it means? I mean, what if a person isn't very well educated, has no access to legal advice, and simply writes in a letter, doing their best? They haven't complied with any of these policies. They haven't filled in any forms. So does it mean the Secretary of State can just put that in the bin?
That's going to be the second of my 3 points.
Oh, I see. Sorry.
But I respectfully agree with the premise of the question. In my submission, the Secretary of State can prescribe forms for the purposes of the immigration rules, because hard-edged rules can be included. But what the Secretary of State can't do is introduce hard-edged rules, including procedural rules such as the use of particular forms, as a prerequisite for being willing to exercise her broad discretion.
And just so that both Mr. Brown and you are on notice, can I just ask another question? Please don't answer it straight away. But I think both of you, I hope will be able to assist us in due course. This reference to imposition of fees and charges may be a red herring, I don't know, but it interests me because in other contexts, one of the subjects I deal with is tax law. And it's a fundamental constitutional principle that before the executive can impose fees or charges on a person, they have to have statutory authority to do so. In other words, the consent of Parliament.
That's the Wilts Dairies case.
Yeah. And it may, as I say, I don't want to set you down an avenue that doesn't need to be explored. But certainly speaking for myself, I would be interested to know what the government say is their legal authority to be imposing fees and charges on people for what is by definition a request that you exercise discretion outside the rules. There may be such a power, but we may need to be shown it.
Yes. Well, I should say, in fairness to my lady friend, that it was that point at the moment doesn't form part of my case, but we'll consider it. At the moment, so I said that I've got 3 points. At the moment, I'm just making submissions about what the policy documents on their proper interpretation say.
Yes.
And I'm trying in my submissions to reconcile what might be taken to be a tension between the requirement on the face of the compassionate circumstances policy to use form SETO if you're making an application for ILR outside the immigration rules, which is what we were doing, and the requirement on the face of the Windrush Scheme document, which says if you're applying for ILR outside the immigration rules under the Windrush Scheme, you need to use the Windrush Scheme form.
I suppose the answer might be that if you're applying under the Windrush Scheme, use the Windrush form. If you know you don't meet the requirements of the Windrush Scheme, use SETO. That might be another way of looking at it.
If there were no other words, that might be the answer. But in my submission, one gets a reconciliation at page 238. And this is back in the compassionate circumstances policy. We've already looked at the passage. It's under the heading applying in the UK for LOTR. applicants in the UK must apply on the application form for the route which most closely matches their circumstances.
You say, well, your client has applied under the route which most closely matches her circumstances because she fulfills 3 of the 4 criteria under Windrush, and therefore that's a closer match than a straightforward LOTR outside and using the general compassionate rules.
Exactly so. And in my respectful submission, that's an unsurprising conclusion because it accords with common sense. If you are, to take my Lord's hypothetical example, an uneducated applicant without legal assistance, and you want the Secretary of State to treat you as an almost Windrush case, which form are you going to most naturally use? Well, the Windrush form.
Well, it also ties in with the practicalities that we see day by day in relation to the way the discretion outside the rules is exercised, for example, in Article 8 cases. Because you'll get somebody applying on the appropriate form for family life, for example, saying, please exercise the policy, and of course that's within the rules. And then there's always that add-on for exceptional circumstances outside the rules, for which there isn't a separate Windrush-type policy, but there's still the residual discretion. And I don't think I've ever seen an application within the rules accompanied by a form SET0 saying, by the way, if I don't fall within, I meet various compassionate circumstances and you should exercise your discretion outside. It happens as a matter of process.
Well, there might be a stronger argument in that example because there's no equivalent to the Windrush form, but here we have got the Windrush form.
Yes.
And I do observe that this wasn't a point that the Secretary of State took below.
No.
It's never been suggested in this case until we've got to this court that, aha, you used the wrong form, and that was the end of it.
And also your client, I think I'm right, all her relatives who've made their own applications have done it under the Windrush scheme.
Yes, well, my learned friend says, well, look at the 2 brothers who were granted leave outside the immigration rules in circumstances where they didn't quite meet the requirements of the scheme. My learned friend says, oh, well, that's different because that discretion was exercised of the Secretary of State's own motion rather than them explicitly requiring it. So in those circumstances, so he says, one didn't need to use Appendix FM form. Well, here we are. Now, in my submission, there was no basis for the appellant to use the form for Appendix FM, which is the way the Secretary of State puts her case in the respondent's notice, because she wasn't applying for leave under the immigration rules. And the Appendix FM form is a form for an application under the immigration rules. And she didn't come close to satisfying the requirements of Appendix FM. She could only get into Appendix FM if she had a partner settled in the UK or a British child, which she had neither. She came closest to Category 4 of the Windrush Scheme. So that's the first of my 3 points on this topic.
And also, if we're talking about the exercise of discretion, you're applying for that, this is me as an untutored lawyer in public. Surely it doesn't matter which formal form you've used, because those are to do with coming within a scheme or the rules. You only get to the discretion if you haven't. So if all roads lead to a discretionary point, it doesn't matter which of the forms you've used to start on that road, because you end up move through that and you're into the discretionary period. That may be a totally bad point.
Well, I respectfully agree, my lord.
Well, the only justification is to be able to charge the fee, and my lord has already raised a point about that.
And it seems to be common ground between you and Mr Brown, but there's no decided authority on this question. Is that right?
Well, so far as we've been able to tell. Yes. My second point then is that to pick up the point that my Lord Justice Singh has already made, a policy which guides the broad statutory discretion to grant leave outside the rules can't elevate a requirement to use a particular form into an absolute rule, because otherwise that would need to be included in the immigration rules. And that is why, in the KA case that we looked at, the policy statement that applications would only be considered if they included biometric information couldn't fetter the Secretary of State's discretion to waive that requirement. So even if there was a policy requirement to use a particular form, if a letter was sent instead of that form saying please exercise your discretion, the Secretary of State would still have to consider doing so. Now, she might conceivably make a rational decision in response to that, saying, no, I'm not going to exercise my discretion in this case because you haven't used the right form. It's very important that you use the right form for the following reasons. It's vital that you pay the fee for the following reasons, and therefore I'm not going to exercise my discretion in your case. But she still has to consider exercising discretion, in my submission. My third point is that even if the Secretary of State could have taken a procedural point and said, I'm not going to consider exercising my discretion unless and until you submit your request in a particular format, that's not what she in fact did. If we could go back, please, to the core bundle. At page 205. In the penultimate paragraph on that page, the answer wasn't the Secretary of State didn't consider exercising her discretion because of the format in which you made your request. The answer was that the Secretary of State didn't consider exercising her discretion because the appellant didn't satisfy the mandatory requirements.
Well, that may be right, but suppose, for the sake of this argument, Mr Brown's argument in substance is correct, and the right form does have to be used. Would this then potentially go to the section 31(2)(a) point? That if the right form has not been used, then it's obvious what the answer is going to be.
Well, not necessarily, because unless the court feels confident that it knows what the Secretary of State's answer to the request to exercise her discretion, notwithstanding the form not being used, would be. Now, if the court has material before it which contains the rationale for the use of that form and concludes, well, it's obvious in light of that rationale what the answer would have been in this case, well, then so be it.
Forgive me, Mr Butler, I haven't made myself clear. This is based on the hypothesis that Mr Brown's contention is correct, that the British oxygen principle is subject to the caveat that if you want a public authority to consider exercising a discretion outside some other rule or policy, then it's within the executive's power to prescribe the form in which that request must be made.
If the executive can fetter its discretion by imposing a procedural requirement to use a particular form, if that is a carve-out to the non-fettering principle, then yes.
But I think what you're really saying is that just to pose that scenario illustrates why the underlying argument must be wrong, because it has the potential completely to undermine British oxygen.
Drive a coach and horses through it. It also would drive a coach and horses through Section 3, subsection 2 of the Immigration Act.
And they don't. There's no express provision that says you must use this form.
Well, that's my first point. My first point
there
is
no express fettering.
My first point is this simply doesn't arise because there's no policy document that imposes a requirement in this context to use the particular form. If I'm wrong about that, then we get to the question of suppose on its proper interpretation, these policy documents do say you have to use this particular form, and if you don't, we won't consider your request for the exercise of discretion. Suppose that's what they say. Is that lawful? In my submission, no. 2 reasons. 1, it contravenes the non-fettering principle. 2, it would be in breach of Section 3, subsection 2 of the Immigration Act.
And you made this point at least obliquely already, but if you look at paragraph 32 of the judgment, core bundle, page 88, paragraph 32, the final sentence, Counsel of the Home Office accepted that the correspondence looked at in entirety included the pre-action correspondence, did include an express request for the exercise of the Secretary of State's discretion for a waiver there. So the Home Secretary on there was wasn't saying you've got to have the form, if you've got the form, you're out of it. They were saying, no, this is where we are. And then their case, the next paragraph, is that on the fair reading of the correspondence, she did.
Yes, well, that's the point we've already looked at.
Yeah.
Well, absolutely. The Secretary of State, as I think I've already indicated, the Secretary of State's position, both in the letter itself, which didn't say we're not considering exercising discretion because you've not used the right form, so the letter itself and the Secretary of State's position before the High Court was you don't need to use a particular form. This is something that, a new point that has been identified by the Secretary of State in this court. And in my respectful submission, it's a bad point. That was then my answer to the Appendix FM form issue. Could I then please turn to my topic 6? And this is the judge's prediction, as I put it, that it was highly likely that if the Secretary of State would consider exercising her discretion to relax the continuous residence requirement, she would exercise the discretion against the appellant. Could I begin, please, with the judge's reasoning? This is in the core bundle at page 93. At paragraph 53, the judge recorded the 4 reasons advanced by the appellant in the letter that we've looked at for waiving the continuous residence requirement. I showed those 4 points already. Then back to paragraph 52, the judge recorded that there was no witness statement from an official in the Home Office setting out what the decision would have been. Nevertheless, he said there was other material. And then the 5th line of paragraph 52, he said 2 of the points made by the claimant as to why discretion should have been exercised in her favour were specifically addressed by the Secretary of State. There's no reason why the Secretary of State wouldn't have addressed them in precisely the same way as part of the exercise of discretion. Can I be clear that I accept the correctness of that conclusion?
I think that flows from your point that the historic injustice point isn't being pursued.
Yes, quite.
Yeah.
Yes. I accept that in light of what was said by the, on behalf of the Secretary of State, in respect of ground 1 in the letter of the 25th of May, the Secretary of State would inevitably not have treated the 1st and 2nd points of paragraph 53 as sufficient to relax the continuous residence requirement. The judge then developed those points at paragraphs 54 through to 62. And as I say, I accept the correctness of that analysis.
Yeah.
But in my submission, the point of real significance advanced by the appellant was the 3rd point, that she could demonstrate strong and subsisting ties to the UK in other ways than the continuous residence requirement. I'll just remind the court what the judge said about that. Paragraph 72 on page 98. It's a proxy for strong and subsisting ties to the UK.
Yeah.
And then if we turn back to page 81, at paragraph 7 of the judgment, the judge noted some of the appellant's ties to the UK, including 7 siblings living in the UK, all of whom have British citizenship. In addition, as her representations to the Secretary of State had explained, but I don't think is recorded in the judgment, she'd studied in the UK, and after her studies regularly visited the UK for up to 6 months at a time between 2008 and 2020, and she's lived here since 2020. And that, in my submission, was the real point of substance that the Secretary of State needed to grapple with when addressing the request to relax the continuous residence requirements.
Also, if you look, and I haven't done this, but one might look at the whole of your client's life and ask the question, which of St Lucia and the UK does she have the greatest strong and subsisting ties to? That would be a useful exercise to undertake.
Yes, in my respectful submission, it would be a useful exercise. I don't say that the Secretary of State would be bound to approach it in that way.
But it's an illustration of a balance, which I suspect would fall in favour of the UK.
Yes, and it's certainly one way in which the Secretary of State could rationally approach the issue.
Yes, that's all it is, but it's something that could be done.
Yes. Now, the judge addressed this point at page 96. If I could ask the court, please, to reread paragraphs 63 and 64.
To say with the greatest respect to the learned judge that it's a little thin on reasoning.
Well, I would respectfully go further and say it's not only thin but wrong, and I'll make my submissions on that.
Well, you say he's doing what this court and other courts have said numerous occasions you're not supposed to do, which is descend into the arena and make the decision yourself. You don't second guess what the decision maker would have done.
Yes, and I respectfully am going to make that submission. I'm going to make it in a moment by reference to the Court of Appeal's decision in Bradbury. Yeah. Before I do that, could I make some particular points about the judge's reasoning? At paragraph 64, lines 1 to 6, the judge seemed to conclude that the Secretary of State would reject the strong and subsisting ties submission on the grounds of the lack of historic injustice to the appellant and her father. Now, as I've already accepted, the judge was entitled to find that the Secretary of State would have concluded that neither the appellant nor her father had suffered historic injustice, and that disposed of the first and second submissions advanced by the appellant. But the difficulty in my submission is in the judge moving from that to the conclusion that the Secretary of State would reject the appellant's third submission. The lack of historic injustice was simply irrelevant to that point for two reasons. First, as I've already shown the court, there's never been a need for a person applying under Windrush Category 4 to demonstrate any historic injustice. It was historic injustice that led to the making of the scheme, but it isn't one of the Category 4 ingredients. Second, the question of historic injustice isn't relevant to the question of strong and subsisting ties to the UK. They're entirely separate points. In my submission, the absence of historic injustice doesn't logically undermine the submission that the appellant has strong and subsisting ties to the UK. the points are apples and oranges. Then at if we go back please to paragraph 64, at lines 7 through to 13, the judge stated that the appellant could have advanced her contention about strong and subsisting ties to the UK as part of an application for leave under the immigration rules, specifically Appendix FM. Now that was a suggestion made by the judge of his own motion. It hadn't been submitted by the Secretary of State. And it was a suggestion that the judge didn't canvass with the parties before handing down judgment.
It wasn't raised during the hearing?
No.
I see.
It's of course more than that. I mean, that's not my real problem with that part of the paragraph. More than that, it's of course true that the appellant could have made an application under the immigration rules, although, as I've said, she doesn't meet the criteria for leave under the immigration rules, and that's not what she was in fact asking for, and it's not what the judge held she was entitled to. She was entitled to an exercise of discretion outside the immigration rules. And specifically for the policy that guides that broad discretion to be applied flexibly. The central point of the request for the Secretary of State to exercise their discretion to relax the continuous residence requirement was that the appellant could satisfy the substance of the requirement in another way. To say that there's a different theoretical route for leave under the immigration rules, which the appellant can't satisfy, is in my submission no answer to that. Now, I accept the Secretary of State might have concluded, I'm not going to relax the continuous residence requirement because you haven't persuaded me that you've got sufficiently strong and subsisting ties. On that basis, I'm not going to exercise my discretion to grant you leave outside the rules, so all that's left for you is to make an application under the rules if you think you can satisfy them. That would be an acceptable response. But it wouldn't be a satisfactory answer, in my submission, for the Secretary of State to ignore the request for her to exercise her discretion to grant leave outside the rules by pointing to the rules. Which, in effect, in my submission, is what the judge has done there. So those are my criticisms of the judge's specific reasoning on that point. There's also then the broader point that my lady has just referred to. There was no material before the judge to indicate how the Secretary of State might have addressed the strong and subsisting ties point. As the judge pointed out at paragraph 63, the Secretary of State didn't refer to this in the correspondence. And as the judge had pointed out at paragraph 52, there was no witness statement addressing the point. Nor, for that matter, was it addressed in the Secretary of State's pleadings or in her skeleton argument in the High Court.
So how did the Section 31 point arise? Was it debated at the hearing?
It was debated at the hearing.
Of the judge's own motion?
No. The counsel for the Secretary of State below orally raised a 31(2)(a) point. But as I have already told this court, the Secretary of State submissions did not include the contention that the answer would have been you should have applied under Appendix FM. That was a point that the judge has thought about after the hearing and included in the judgment.
Right.
And he may have picked it up from the original letter of refusal, which said something very vague about there may be alternative routes for you to apply.
Yes, yes, it may be that. But I come now, if I may, to this point about the absence of material and the question of, well, what should the judge have done in those circumstances?
Sorry, just to go back, it was a 2-day hearing before the the judge, and so
Yes.
that in terms of a position from the Home Secretary, there was nothing in writing at all on this point, and so the judge's understanding of what the Home Secretary might or might not have considered developed during oral submissions from counsel.
Yes, I'm afraid, my lord, I cannot remember, and I haven't before now attempted to turn my recollection
As
to
to what the sequence of events.
to exactly how the case was put by the Secretary of State. But I can say with confidence that the Appendix FM point wasn't raised.
Yes.
Quite how the Secretary of State advanced the 31-2A point, I'm afraid I can't remember.
It might be, this is conjecture, that the judge said to Mr. Hanson, well, what if I'm against you, Mr. Hanson? And I find that there was a breach here, and then submissions developed.
I'm afraid I can't assist the court on that point. So I posed the question, what should the judge have done in these circumstances? And in my submission, the answer to that is clear in light of this court's judgment in the case of Bradbury. That is in the authorities bundle at tab 13. I should say that this post-dates the judge's judgment.
Right.
So he didn't have the advantage of the court's reasoning in Bradbury.
But there's nothing in Bradbury that's particularly new. I mean, there are plenty of other cases that say much the same.
Yes, it didn't break, my submission didn't break any new ground.
He referred, didn't he, to the Plan B case?
Yes, he did, because I had a copy of Plan B run down to court when the 31-2A point developed.
Bradbury doesn't, just on the way the case is reported, it doesn't list any authorities, any previous authorities referred to. Just leafing through to see whether that's just a mistake of the editor.
Oh, yes.
But they seem to, no, they do refer to it, paragraph 55, for example.
The facts of this were that the National...
Brace yourself, limited. Yes.
The National Park Authority had omitted to obtain certain assessments before granting planning permission. As it turned out, the assessments came to the same conclusion as the planning committee, such as their absence made no difference. Those are the facts of the case. The Court of Appeal also gave some helpful general guidance on how the 31-2 capital A highly likely test should be applied. And could I show the court, please, page 446. Paragraph 70, in the third line from the end of that paragraph, so the line which begins in other words, Lord Justice Lewis observed that the conduct complained of is the legal error which would justify a remedy, but for the section 31-2A question. Now here, the legal error was the failure to consider exercising the discretion to relax or waive the continuous residence requirement. In effect, it was a failure to make a decision. Then at paragraph 71, first sentence, Lord Justice Lewis said that the court is concerned with evaluating the significance of the error to the decision-making process. Here, in our case, the significance was that the relevant decision wasn't taken. Over leaf, if you could please read the first 4 lines on that page, beginning "It's not for the court to try and predict."
Well, is that right? Isn't that exactly what the legislation does require a court? Is it highly likely? So I'm just being devil's advocate.
No, I have had the same difficulty with
The following
language
sentence
used,
is
both
clearly
in,
right.
both in this and the Greenfields case. It seems to be quite a fine line. The way I reconcile the requirements of section 31-2A and what the guidance that's given in these cases is that the court is entitled to work out what the Secretary of State or the decision maker would do based on material that's already there from the Secretary of State. But what the court can't do is to, I think the court's been too polite to use the word speculate, but can't speculate what the Secretary of State might do.
It may be that the phrase "might have done" is an indication of a state of affairs which falls well below the high level of the test. If you're just trying to predict what they might have done, you're not in a highly likely situation.
Yes, but what one certainly shouldn't do, in my submission, is, in the absence of material, ask, well, how might I take that decision if I was standing in the Secretary of State's shoes?
Well, on a very, very clear case on the facts, you might be in that position.
Well,
this may not be that.
If the only rational conclusion were a particular outcome, or it's so obvious, falling short of only rational conclusion, it's so obvious that it's highly likely.
Usually, and again, I stress what we said in the Friends of the Earth case, Plan B Earth, that one doesn't want to be prescriptive.
No.
Because it all depends on the facts. But usually, this arises, let's say in the planning context, that there's a proposal to have a housing development in a greenfield site or something like that. And the discretion has been exercised. It's just that although there were 99 good reasons for allowing the housing development on one side, one point to do with newts or bats or something was overlooked. So it's held that a material consideration has not been taken into account. But there's no doubt that the discretion was exercised, and given all the material, the 99 good reasons for allowing the development, the court is in a position where, on evidence, it can confidently say it is highly likely the outcome would be the same. Because the presence of one bat is not, with respect, going to make a difference to the need for all this housing. Right? But I think one of your points may be that this isn't that kind of case. The legal error that's been committed is never to exercise the discretion in the first place.
No, there's no decision. And if I may respectfully say, the words that my lord just used, on evidence, are important. If the relevant decision maker has made a decision, has committed an error, for example in the Bradbury case, by not having regard to a particular assessment, but it's clear that had they considered the assessment, they would have reached the same conclusion because, in substance, they considered the identical point and imposed the identical conditions that had been recommended by the assessment. Well, then it is obvious what the decision maker would have done. But by contrast, if the decision maker has never considered the points and there's no evidence before the court as to how the point might have been addressed, well, in that situation, in my submission, it wouldn't be appropriate for the court to try to predict the outcome.
I think we don't need to go down that route in this case because, as you've rightly pointed out, there is no evidence because there was never any attempt to grapple with the exercise of the discretion in the first place. But there is this concern in the absence of evidence. On the one hand, you do need evidence, but the evidence quite often is quite self-serving.
Yes.
And so you do tend to get, in planning cases in particular, evidence from the decision makers saying, well, you know, it wouldn't have made the blindest bit of difference to me. And you then have to take that with a certain amount of scepticism because they're trying to work out with the light of hindsight what would have happened. And I think that this court has been stressing how difficult it is to apply this test because it is an exceptional test.
Yes.
I mean, it's not quite as stringent as it was at common law. It's gone down from absolute certainty to highly likely.
But not far off, as the
But
court
not
said
far
in Plan
off.
B.
Yeah.
And it's also imposed a duty on the court, whereas it used previously to be discretion.
Yes.
But nevertheless, I mean, what we said in Plan B, and Mr. Brown may contest this, I don't know, but certainly what we said, you cited in Bradbury at paragraph 273, is that Parliament has not changed the fundamental relationship between the courts and the executive. In almost every judicial review case, we stress, because the public doesn't, I'm afraid, always understand this, that we are not sitting to hear an appeal.
No.
On the merits of a case.
Well, and for two very good reasons, if I may say so. One is institutional competence and expertise. This court is not in a position to make judgments on immigration control in the way that the Home Department, with its long experience and expert officials, is. And the second reason is democratic accountability. Right. Parliament has given this function to the Secretary of State, not to the judiciary. And it would contravene, in my respectful submission, the separation of powers doctrine for the judiciary to take on that decision-making function. So I absolutely respectfully agree with what my Lord said for those reasons.
But this judge, Mr Justice Sheldon, is very, very experienced in the field of public law.
Yes.
But you're saying that he's made basic error here.
Yes, and I do respectfully endorse what my Lord says, that this is obviously a highly regarded public lawyer with a long experience at the bar of public law and on the bench. But be that as it may, in my submission, there was an error in this case.
Homer sometimes nods. As they
Yes,
say.
exactly.
Yes.
Exactly.
Lord Bingham, when he was still in the commercial court, was held by the House of Lords once to have misapplied the burden of proof in a shipping case,
Yes.
having correctly directed himself at the outset of his judgment. So we all make mistakes.
Yes. I just wanted to, where I'd left Bradbury, I think we've slightly gone through a bit more. Covered some of the points already, but where I'd got to was the end of paragraph 71, and I just wanted to make the point that the formulation that Lord Justice Lewis used there is the same formulation that he used in the Greenfields case for your reference, paragraph 73 of Greenfields. And I note that Greenfields was handed down on the same day as Bradbury. So there's, understandably, they come as a pair.
Yes, the Constitution was different.
Yes, it was. Yeah. But Lord Justice Lewis gave the leading judgment in both cases. I know that my Lord Justice Singh, gave a concurring judgment in Greenfields.
Yeah, essentially what I said, and I think I was agreeing with Lord Justice Lewis, is that there's a need for evidence.
Yes. Yes. But I would respectfully agree with my lady's point that I would respectfully discourage this court from suggesting that decision makers should routinely put in evidence of what they say they would have done had an error not been made because of the risk, the inevitable subconscious human desire to self-justify. And it's maybe unhelpful.
Well, we're starting to see it, and we're starting to see the opposing party then saying, well, you haven't put in evidence about what you would have done. And it sort of turns into satellite litigation in a way. But, you know, there are certain cases that can be clear-cut. My Lord's given one example. Another is, you know, we had a recent case called Bibu in the immigration sphere, where an entry clearance visa was refused for 4 discrete grounds, and one of them was under attack. And we said, well, even if you're right about all of that, look at the other 4. They all none of those have been challenged. Each one of them would independently have given rise to exactly the same result. We're into section 31(2)(a) territory.
Yes, yes. And Bradbury is quite a good example of a situation in which the court can say with confidence what the decision would have been. Could I just point out that what the court said at the top of page 447 is then underscored by what's said at the top of page 448. And in the third line on that page, Lord Justice Lewis said, midway through that line, the section emphatically doesn't require the court to embark on an exercise where the error is left out of account and the court tries to predict what the public body would have done if the error hadn't been made.
No.
Approaching section 31(2)(a) in that way would run the risk of the court forming a view on the merits and deciding if it thinks the public body would reach that view if it hadn't made the error. Same point, a little bit more developed. And then the court, well certainly my Lord Justice Singh has already noted what is set out at page 447. There's the citation of Plan B Earth, and I'd ask the court to note in particular what's said in the indented paragraph 273. And then at paragraph 74, line 5, Lord Justice Lewis emphasised that the 31(2)(a) test is a, quote, high test to surmount. Nothing new there, but just so that you've got the references. And so we respectfully say that the judge strayed into what's been described as the forbidden territory and attempted to predict a decision that Parliament has assigned to the Secretary of State. And for those reasons, we respectfully ask this court to quash the Secretary of State's refusal to consider exercising her discretion to grant leave outside the immigration rules, even though the continuous residence requirement wasn't satisfied. Unless the court has any further questions, those are my submissions.
No, that's very effectively done, and within time.
Within time. Thank you.
Thank you, Mr. Butler. Yes, Mr. Brown.
My lords, my lady, what I propose to do is get straight into the heart of the matter, if I may, and certainly the central point in terms of what the court's heard submissions on so far has been a respondent's motion, but I won't address all of the points. Hopefully, as I make my submissions, the real battleground between us will become clear. So on the Secretary of State's case, the relevant process is as follows. A claimant or a person in the position of the claimant, i.e. the appellant, can look to the immigration rules. She can assess the written criteria within the immigration rules and make an application if she believes that she qualifies. She can also look to any relevant extra statutory scheme, here relevantly the Windrush Scheme. The Windrush Scheme itself represents the view of the Secretary of State, accountable to Parliament, as to which specific types of application or person should qualify for the exceptional leave that is granted pursuant to the Windrush Scheme. Other schemes exist and are familiar to the court. The Afghan scheme, the Ukraine scheme are examples of that. If a claimant does not fall within the terms of the rules or any published scheme, then she may ask the Secretary of State to exercise discretion to grant leave outside the rules. As the court has been shown by reference to Munir, that is an extremely wide discretion and is essentially apt to deal with all circumstances. So there is, in fact, no limit on the scope of leave outside the rules, also known as LOTR or LOTR. The position the Secretary of State adopts is that it is important to achieve the goal of consistency in decision making, and it is also important not to engender false hope. It is theoretically possible that anybody in the world could make an application to the Secretary of State, whatever the extent of their connection to the United Kingdom, and ask the Secretary of State to exercise her discretion. What the Secretary of State seeks to achieve is to set out, for the benefit of applicants and the benefit of those who are charged with making decisions, what the sort of characteristics are that are likely to mean that she exercises her discretion outside of the rules in the applicant's favour. In order to further that goal, the Secretary of State publishes policies And we say that the policy that governs applications for LOTA is what we describe as the LOTA policy, which the court has been shown in part and which I wish to take the court back to. And to encapsulate our submission in the respondent's notice, what we say is that it is open to the Secretary of State to set out a process which he expects individuals to follow. That itself furthers a range of public policy goals, not least in the present circumstances, that would have avoided the issue of there being a day's argument before the High Court in order to decide the question of whether an application has in fact been made. So it provides a very clear and cogent process which operates to the benefit of applicants. It also operates to the benefit of decision makers because it will ensure that a decision maker with the relevant expertise evaluates the application. I'll address the question of fees in due course, but my submission is that nothing in this process is affected by the fact that a fee may or may not be chargeable in the circumstances. Responding to my Lord Justice Singh's questions, there is statutory authority for the levying of fees. Rather than me seeking to provide the court with the specific details, I will do that in writing. But the short answer is that it's in primary legislation and secondary legislation. The court, my Lord Justice Singh, I think asks a more fundamental question, that given that the law as it is has stood for 50 years, the British Oxford principle requires there to be entitlement to access the exercise of discretion. Can there be a fee in such circumstances? We would say in response to that the correct way of looking at it is looking at the substantive benefit. The substantive benefit is not the discretion. The substantive benefit is the conferral of, in this case, ILR or some other immigration status, not the discretion itself. And it's the view of Parliament, and has been for many, many years, that that benefit justifies fees because of all of the advantages it brings with it. So there may be other cases when it would not be permissible for there to be a fee on a discretionary application, but this is not one of them because it is so closely analogous to the circumstances where Parliament has determined that fees should be payable.
That would certainly be a justification of a scheme where there wasn't a fee required to trigger the exercise of discretion, but if the discretion was granted in favour of allowing indefinite leave to remain, then a fee would be payable to finalise the process.
No, the fee would be payable on the application, my Lord.
I know that's what you're saying.
Yes.
But I'm saying your submission certainly would, if it's the benefit that triggers the justification of the fee, the benefit being allowed, succeeding, then it perhaps only should be payable at that stage. There used to be, when people applied for the status of silk, you paid something on the application, but if you got it, you paid more. I think that was certainly the initial scheme. That's the model I got in mind.
Yes, my Lord, noted. The court would appreciate that the fee issue in the immigration context has a long history in this court.
Yes, no, I've got that, but I'm just was listening to your submission, focused
my Lord,
on the benefit, and you're only going to get the benefit if you succeed.
I'm synthesising a policy view as to the purpose of fees. One of the benefits, and a very fundamental benefit, is that if one is successful, one accesses the rights which are plainly commensurate with the fee that is levied. There are other benefits in terms of funding the general work of the Home Office.
And it may be said to be a benefit just simply to have the case considered under the discretionary scheme, win or lose. Yeah.
Indeed. So today I'm not looking to advance a policy justification for fees. I'm simply giving background information in relation to the fee process. In terms of where we are, though, so the the lot of policy is in the supplemental bundle at page 213. If I can perhaps just go through that and why we say that is apt to cover the exercise of discretion. And one sees then at 230, guidance for decision makers considering leave outside the immigration rules on the basis of compelling, compassionate grounds. Now, of course, we note the point that the claimant seeks to distinguish herself on the basis that, although it is partly compelling, compassionate grounds, and indeed the reaction protocol letter specifically refers to compassionate grounds, it is put slightly more widely than that. That really goes to perhaps what the heart of the difference is between us, namely whether it's for the claimant to decide herself, how to go about this process, or whether it is open to the Secretary of State to effectively set out how the process ought to be followed. Now, what the guidance says, so see please page 232, refers to when it may be appropriate to exercise discretion to grant leave outside the immigration rules, LOTR, on the basis of compelling, compassionate grounds other than family and private life, medical asylum or protection grounds. Then it's guidance to decision makers considering entry clearance, leave to remain and ILR applications. Next paragraph, circumstances in which someone may be granted LOTR are covered either by this guidance or separate guidance relating to European Convention on ECHR, medical discretion leave, or where there is an existing published concession. And what that is saying then is that that occupies the field, because one has the concessions, so for example the Windrush Scheme, but the Secretary of State knows, because it has been the law for half a century, that she must consider the exercise of discretion more widely, and this is the basis upon which she will do it. So if there's a more appropriate prescribed policy or concession, then that is where one looks first. And that's why I said when starting that you look first to the rules, then to a concession, then to the lot of policy. If you're not within that, then this is the arrangement that is put in place in order to ensure that there is effective consideration on a discretionary basis.
Yeah. Can you just help me in that paragraph with, maybe it's where the commas are, the phrase discretionary leave, capital D, capital L, how does that fit in? Is it said there's separate guidance about it, or does that qualifying Article 3 medical?
Guidance.
Yeah, so there is other guidance.
Other guidance.
Yes.
And is that irrelevant to what we're considering in this case?
Well, it's not said to be of such relevance as to require argument on it. Yeah. So broadly speaking, that's the point in the appeal. Is it sufficient for the Secretary of State to say, well, these are the different routes, and I've made provision for all of them?
This is guidance given to the caseworkers at the Home Office. It's not guidance given to individuals making claims.
No, but it's published, and what generally applies when there's published guidance of this nature is that members of the public will say, well, that is the guidance, and effectively, therefore, that establishes the guidance which I'm entitled to rely upon myself. So if the shoe on the other foot, and there was something specifically that said a claimant ought to be granted leave in these circumstances, the claimant would pray that in aid. So, respect for my lady, there's no issue that arises with this being directed to caseworkers, because it is effectively setting out what the policy position is here.
Is your submission that it's impossible for the discretion to be exercised in circumstances which fall outside any of the published guidance?
No, that is not my submission, because as one has seen in the context of the claimant's brothers, there's another source of the discretion, which is the Secretary of State of her own volition, simply granting LOTR, which the Secretary of State does from time to time.
Insofar as, I imagine your case is, that this claimant does not fall within this guidance, which deals with compassionate grounds. Why is this relevant to the appeal at all? Because she falls into a category which is not covered by express guidance.
It's covered by this express guidance. That's our respondent's notice point, is that it's a catch-all.
That's
You
your
say
case.
it's a general catch-all, even though it only refers to compassionate circumstances.
Yeah. because, broadly speaking, the Secretary is indicating to the world at large that there has to be some compassionate circumstances, really, before I consider exercising my discretion. Does that mean that there would not be some case where the individual says, well, there's no compelling compassionate circumstances, but nevertheless, I have got an argument of some sort? Well, yes, that is conceivable, but that's not this case, and it's unlikely.
Which form do they use then?
Well, I understand my lord to be asking me the question, well, is it then theoretically possible that there is a yet further category of cases? Yes. And of course there is. And I
say never. Yeah.
I wouldn't say never. It would be wrong to do so because there's always another case. The question is really, well, what about this case, the claimant's case? What is it about her case that means that it's not, in fact, governed by the published route? And we say that, well, there's nothing at all. It's very clearly within the guidance that has been promulgated for that purpose. It's not the hypothetical case which may or may not come to fruit in the future, where somebody says, well, what about these things that you have simply never thought about before? The Secretary of State has thought about the situation whereby there may be compelling compassionate circumstances. That's not just in relation to family matters, but it could also involve anything to do with historical injustice, etc. And she has made provision for it. And the real question is, well, what is problematic in legal terms about that?
Because I think your title is there's nothing that unusual about this claimant's factual circumstances. She's been here off and on, but largely here, in recent years, 2 children, brothers and sisters, family here. That could apply to a large number of people who are here without leave.
So assume for the sake of argument that is the sort of case that a Home Office caseworker would deal with day in, day out. Yeah. And what is the objection in principle then to having a system which requires that to be put on a form of the claimant's choice? And I'll come on to the forms point in a moment, but it's a visa application form which they consider to closely meet their circumstances. And then, broadly speaking, will direct it to a decision maker who is trained and has experience in considering, for example, family connections or whatever it may be, making a decision on that application. And subject to the points that have been hinted at, which are effectively fees, and then a point about the form in a moment, we say, well, there's nothing. There's nothing in the authorities that says that this is problematic, and there's no prejudice to the claimant. So, again, just for the sake of argument, leaving aside the fee question, what is objectionable with the claimant, in terms of the claimant doing what the judge indicated she could do, and which we say in our skeleton argument she can do, which is simply making the form on the form which is most closely connected to her circumstances, which would appear to be the Appendix FM form. And that does provide a route through to all of the potential benefits that she seeks. And therefore we say that there's no reason in law why that should not be done.
Why not form SETO then?
That could be done. That would be considered. That would also mean that it would go to a decision maker. As the policy makes...
The trouble is with all of this, Mr Brown, that although I understand the policy arguments, somebody reading this might well think, well, the form which gives rise to the route that most closely matches my circumstances is the Windrush form, because I've ticked 3 of the boxes for a Windrush, and I don't tick the 4th, but at least if I tick this form, according to you, it's going to go to somebody who has experience in Windrush matters and will know about all of that. Whereas if I go down SET0, it might go to somebody who has no experience in that whatsoever.
The Windrush scheme is not a visa application form.
No.
When it refers to forms here, and one can't see it on the PDF document, but one does click through on the hyperlink. When one clicks on the form link, it goes through to the visa application forms. That's what the form is referring to. So it's talking about forms for visas under the immigration rules. I appreciate we've got a slightly unusual situation here, which they're saying, well, yes, but you've got this extra statutory process, so that seems to be advantageous to me, so I'll go down that route. But it's not a visa application form as such. It's an extra statutory scheme which provides for specific consideration solely by reference to its criteria.
Well, sorry, but SET0, which is dealing with leave outside the rules, can't be an application for a visa under the rules, can it?
That broadly, well, my lady, perhaps I'm taking it too quickly. Let's just go through the form in a bit more detail. But broadly speaking, I appreciate there's always a temptation to improve, but here there is a scheme which deals perfectly properly with precisely the situation before the court. We would respectfully say that there'd have to be really some striking legal reason why this court should say that that is not lawful or not the correct approach that should be applied in circumstances where it's been set up for good reason. But just going through the policy form itself then, the introduction tells the reader that this is about the background, important principles, reasons to grant leave outside the rules, documentary evidence and LOTR in respect of children and those with children. So just assume for the sake of this point of the argument that it is legitimate then for Windrush applications only to be dealt with in the Windrush scheme if they in fact meet the terms of the Windrush scheme. And here then one has what is, to all intents and purposes, simply an ordinary application. There may be some overlapping features of the Windrush scheme, but it's not within those criteria, so therefore it needs to find another home. What this guidance says then is that the immigration rules are designed to provide for the vast majority of those...
Where are you reading from?
I'm sorry, my lord. At page 234, background. The first paragraph immigration rules deal with most of, or the vast majority of those wishing to enter or remain in the UK. However, residual discretionary power under the 1971 Act. So there can be no doubt that the Secretary of State understands that she has that discretionary power. This is why this is really about process as opposed to anything else. Then there is history in terms of arrangements that have been made to formalise certain types of applications. And that is important because it illustrates the level of complexity of the decision-making process. This is clearly a field where there is a very high volume of applications, and there needs to be a rigorous and predictable way of managing that. And that is what these policies are intended to deliver. So legislative change, but then even that interacts with what's done outside of the immigration rules. So in the family and private life cases, I won't read it out, but if I can just ask the court to read what's set out through to important principles. What the policy document is telling the reader then is that LOSA then is extremely wide, and indeed there are many examples, Afghan judges, individuals in Diego Garcia, Ukraine, all of that. They can all be accommodated within the wide discretionary power that is available for that purpose. However, important principles, next page, it should be rare. So this is not a parallel immigration route as such. And indeed that point is made in the second paragraph. There isn't a parallel regime whereby one looks at, for example, the spirit and purpose of what Parliament might be looking to achieve and then constructs a parallel regime operating alongside it. It's a discretion which should be used sparingly when there are factors that warrant a grant of leave, despite the requirements of the immigration rules or specific policies having not been met. And that is our case.
I think conceptually, Mr. Brown, it may be important always to keep in mind the distinction between two different things. One is granting what you've called the benefit.
Yeah.
So what is the end product? And there's a logically prior question, which is a willingness to consider.
Yeah.
Now, it may well be that the outcome will be no.
Of course.
Because you don't meet, because it's not a parallel regime, it's meant to be rare, and so on and so forth. So that may deal with the second stage, but I think in this case we're dealing with the first stage, which is the non-fettering principle.
Yes.
And are you saying that if, for example, somebody just writes in a letter because they can't read very well, they may not be very proficient in English, they have no legal advice, they don't know what really they're doing, but they simply ask the Home Office to consider their case. Are you saying that there's no obligation under the non-fettering principle for the Home Office to consider their case?
Yes, we are saying that in circumstances where a process has been put in place to allow one to exercise the relevant legal right, then that process must be followed. In the same way that one can't simply write a letter to this court and say, can you please just have a look at the decision? One has to issue a judicial review claim form because that is part of the process of accessing the legal right in question. And there's no principal reason why that is different here. So one can think of all sorts of circumstances. Somebody sent a text message to a Home Office officer saying, please, can you look at this? Is that really sufficient then to trigger the British oxygen right when it's done in such an informal basis? And one might say, well, that's the only means that they might have had available to them at the time. But we would say it'd be striking and unusual if it were not possible to impose some sort of procedural process on these arrangements in order to make it manageable, because otherwise it would not be.
So it is your case that in the present case, the Home Secretary, having decided that the application didn't fall within the Windrush scheme, didn't find that Roman numeral 1 and 2 of the 4 reasons, which are conceded 1 and 2 don't apply, should simply not have purported to exercise any discretion and simply said you've got to go back to Go and do what the judge said, issue your application under Form FM and take your chances under that.
Indeed, as was said also in the first response, I think it was at page 200, we can go back to it, but the point my lady made is that is precisely...
Yeah. And so what you said the judge was entirely in order in what he did, because he got to that, although it hadn't been the subject of submissions, he got to that position.
Yeah.
So well, look, if she did apply under FM, there's nothing that would lift her into the cohort of cases that were likely to be granted.
He did get to the right answer by that alternative route. Yeah. And my Lord Justice Singh essentially raised this with the claimant in argument. Is that another way?
It's highly unlikely she would have succeeded under that.
Yes, and that is right. We say that if
I can see that.
She'd done that, and that the judge is right to identify that. But I appreciate that the journey was a slightly different one, but only slightly. Then the policy then sets out the general process, and claimant says, well, I want ILR, I don't want anything less than ILR. What the lot of policy, broadly speaking, envisages is that the existing, i.e. the immigration rule routes for ILR should be the primary route. So if somebody, for example, has been here for a period of time but do not meet the minimum period for qualifying for an ILR route, and ordinarily LOTA will be granted in order to ensure that they can remain and go on a journey to ILR. However, it is possible to apply for ILR under the LOTA policy.
I think you misspoke. I think what you meant was that DLR would be granted to allow them to go on the route to ILR.
Well, there could be a short-term LOTR, LOTA grant, so one can have time-limited leave-out.
But it wouldn't be ILR.
No, it would be...
What you said was ILR.
No, my lady, I misspoep
in
that
misspoke.
sense. Yes, but that is right. What I meant to say then is that there would be effectively a grant of LOTA.
Yeah, to allow them to go onto the pathway.
Yeah, exactly. So that is, again, not objectionable in terms of substantive rights. The claimant's only answer really is to say, well, because of the analogy which I draw myself with the Windrush Scheme, if I were in the Windrush Scheme, then I wouldn't have to go on that route. I would just go straight to ILR and potentially even straight to citizenship because of the way that the Windrush Scheme operates. But the answer to that is, well, you're not in the Windrush Scheme. The Windrush Scheme does operate the framework which Secretary of State, accountable to Parliament, has decided should apply in this exceptional circumstance. I have not closed my mind to the exercise of discretion. Here are the circumstances in which I will consider the exercise of discretion. And we say that that is legally unimpeachable as a process. There is no principle that says that the claimant has effectively to dictate the basis on which the discretion is operated. Because what the claimant's submission effectively comes down to is that they determine the form, they determine the basis on which discretion ought to be operated, i.e., are you sufficiently analogous to the Windrush Scheme criteria, even though I'm outside of it? And they say, well, therefore, this is the outcome. And the Secretary of State says, no, I will determine the basis on which you will apply for the discretion, and I will apply the sorts of criteria which seem to me to be sufficient to justify an exceptional grant. That's really the battleground.
I take it you're not saying, suppose you've got this scenario, somebody applies under the Windrush Scheme, thinks they meet the criteria, but the caseworker says, no, you don't meet criterion 1 or criterion 2, for whatever reason. Caseworker would then ordinarily, I think, go on to consider the exercise of discretion outside the rules. Or are you saying that they've got to go back to go at that stage and issue a fresh form saying, well, now that the caseworker has decided that I don't meet the requirements of the Windrush Scheme, I've got to go all over again and put it before...
No, but broadly speaking, what would happen is what happened here is that the caseworker, specialist Windrush caseworker, will generally say, well, you don't meet those criteria. My job is to decide whether you do meet them, bearing in mind that there's all sorts of discretionary consideration built into the Windrush.
So you are saying that you'd have to go all around the houses again?
If you're outside, then you say go around the houses.
And yet that doesn't happen when you make an application within the rules. If you make an application within the immigration rules, and it's held by the caseworker that you don't meet the criteria within the rules, they immediately proceed to decide the discretion outside the rules.
Yes, because that's the process that's being put in place specifically for dealing with cases that are outside the rules, which this case is. Because one can readily see the problem if you have a freestanding scheme such as the Windrush Scheme, which is taking the claimant's argument to its logical extreme, effectively open to anybody. Let's just say an Afghan individual decides to apply under the Windrush Scheme. Yeah. So fine, I'm nowhere near any of the criteria, but why can you not then exercise your general discretion and bring me to the United Kingdom? There's no fees chargeable in those circumstances. I mean, why could that claimant not do precisely the same thing and effectively try and themselves put a fetter on how this process of considering discretion is intended to operate? And we say that that's highly problematic. One can see that there might be a particular case, i.e. the claimant's case, where it might seem that there are good reasons for it. But in terms of the general structure, it creates the sorts of difficulties that I'm exploring with the court. And that's why far better to have the approach which was referred to in the original action letter, which the judge had recognised, which is to effectively treat the Windrush Scheme, which does have discretions within the scheme. But if you're not within the scheme, then that is it. Because the Secretary of State knows that she has a wide residual discretion, which is apt to cover precisely the circumstances.
The problem here is that the Secretary of State did not make a decision exercising her discretion. Yeah, that was not on the you challenge, but on the findings of the judge.
Correct.
And so there's a vacuum there. We don't know whether the Secretary of State would have carried on within part of this same exercise to look at this claimant within the structure of the guidance that we've got open now, or simply said, no, I'm not exercising my discretion on your case. You've got to apply separately under FM to come back, which is what the judge.
But what the judge said and what we say in our skeleton argument is, of course you can make that application. If your argument is there are effectively compelling reasons for you to be granted ILR, then you may make that application and it will be considered. It may involve a fee, but assuming that the fee is lawful for the sake of argument, what is the problem with that?
Yeah.
And that's the position of, effectively the position of the judge and the position that we adopt here, is that that will then be considered. So there's no vacuum, my lord.
Yeah.
The claimant has not made the application.
The administrative arrangements that the lady referred to of if it goes under the general scheme of FM, it won't necessarily be considered by an officer in the Home Office who's familiar with the Windrush elements, which,
yes.
Although she fails to trigger Windrush, are very much part of this claimant's experience,
yes.
her life, her family.
Well, the danger of the Windrush elements is that it becomes far too vague to be manageable, because if that is said to effectively give rise to some sort of concrete legal entitlement, then we would say, well...
Yeah, then she'd come within the scheme.
Yeah, exactly.
Yes, yes.
So the Windrush elements are the terms of the scheme.
Yeah.
That is the only basis on which that extra statutory concession operates here. The fact that there may have been Windrush generation family members for present purposes is potentially relevant on the basis that anything is potentially relevant, but it's relevant in terms of an overall evaluation of the entitlement to leave outside the rules and no more.
And I think your point is that the judge's decision is not to say that the Home Secretary, at the end of an entire process, would be highly likely to refuse any application made by this individual. The judge said, no, it needs to be considered by the Home Secretary in the exercise of her discretion under the ordinary policy which we now have open with an FM application. So
well, the judge did two things, as I understand it. First of all, is to say that that would be the route for the claimant, and
the ordinary way to do it.
Yeah, the claimant can still do it. On the facts presented and the arguments, it's highly likely that that would not result in a positive finding, because the historic injustice points...
Yes, highly likely to achieve a positive finding, because she can go under FM.
Yes.
Yeah.
I'm keen to keep those two aspects of the judgment separated to some extent, because they are effectively freestanding. The moment we're still on respondent's notice in terms of whether this is, in fact, a legitimate way to arrange the structure. Because if it is the case that it is legitimate, i.e. we're right on the respondent's notice, then the appeal should be dismissed because the application has not been made, and therefore the refusal has to be maintained in the absence of an application. That's our answer to my Lord's point on that. What I propose to do then, just before lunch, is just quickly identify other features then of the policy. So the reasons to grant LOTR, so broadly speaking, compelling, compassionate factors, exceptional circumstances. And examples are given. And to emphasise, the purpose of this is not to engender false hope so that people make speculative applications from anywhere in the world. It is to indicate the sorts of circumstances that will mean that, that one's likely not just to be able to apply, but actually obtain a positive outcome. Then next page, so 236, documentary evidence. So all of the documentary evidence that has been adduced on the Windrush application can be brought here. Then in respect of children and those with children, an appointed is made by this claimant that the Section 55 duty should be borne into consideration, and it would be on an application. See what is said at page 7 of 13. Then process, so applying in the UK for LOTA. So it is right then that they must apply an application form for the route which most closely matches their circumstances. So not precisely the right form, but the one that is closest to their circumstances, and pay the relevant fees and charges. So that link does in fact link through to the visa application forms. What we say is, in context, what this is directing one to is to the immigration rule bases, so visa application form routes, and relevant fees and charges. There is fee waiver available for the family and private life form, so see the third paragraph. It is right that, generally speaking, there is no fee waiver for an ILR application made outside the rules. So we acknowledge that that means that a fee is payable, but on the assumption that that fee is lawful, we say that that doesn't create any legal impediment to this process. Because again, just to emphasise, one's not paying for the British Oxygen discretion as such, one is simply paying for what is otherwise a process which Parliament has considered should be chargeable.
But somebody has decided at some point that it's not chargeable for the Windrush application.
Yeah. Yes, so as to whether that itself has a statutory basis, I will check. But that is right, that route doesn't have a fee. And indeed, that's the same for all certain other routes as well. Recollection in terms of the Afghan litigation is that the same LOTA process applies broadly, that fees may be payable, but certainly other schemes have no fees, but that's simply a policy decision. But that fee benefit is the same as the substantive benefit. It applies to those who Parliament and Secretary of State have decided should qualify. It doesn't apply to the wider cohort who may be near misses or...
Well, that's spelt out clearly in the policy. On the face of the policy, you look at page 239, it's made absolutely crystal clear that if you don't qualify under ARAP, you've got to go under the other form.
Yeah, precisely so. So ARAP then, as I recall, no fee, but if one's applying for LOTA because one doesn't fall within ARAP, then you'll be in precisely the same situation. One would have to pay the fee. Then conditions on LOTA, but one can see then over page 11, it is possible to apply for ILR, but the expectation is applicants should start a route to ILR and serve a probationary period of limited leave before being eligible to apply for ILR. However, there may be an exceptionally unusual case where ILR is the only viable option.
If somebody did succeed under the Windrush scheme, was the consequence that they were entitled to ILR?
ILR is one of the entitlements, yes.
Or citizenship.
Yeah.
Sometimes.
Yeah.
But it wouldn't be limited leave on the path to...
No.
The least you'd get is ILR.
Yes. Certainly I can't, well, I'll check that, but the logic is that you're being conferred with a status which in substance you already had.
Yes.
And therefore it's going to be ILR, right of abode or citizenship.
Had you finished the document?
Yeah, I had.
But just a minute before, I'm just sitting here thinking about the outcome of the appeal, one way or the other. If the appeal is dismissed, then this claimant, the judge has accepted, can, and I think you accept, can issue a fresh application on Form FN and trigger the discretionary consideration under this guidance. If the appeal is allowed, to the extent that we would to hold that the judge shouldn't have found as he did on the highly likely principle, the discretionary stage goes back to the Home Secretary to undertake again.
Yes, but it goes back
presumably on, you would say, on the same guidance?
No, presumably by reference to the Windrush Scheme, because the claimant's logic is that it should be considered by the Windrush Task Force.
Yes.
And they should decide effectively the lot of risk.
And no fee will be paid. So there is a difference between. I'm just wondering whether
there is. As I understand,
two bald-headed men arguing about a comb, but whether the appeal succeeds or fails, the claimant's in the same position. She's not. I can.
She will probably say, "Well, actually, I'm more likely to get ILR rather than something putting me on a path to ILR under the Windrush Scheme."
I can see. Yeah. Good. Well, that's a convenient moment, I suspect. 2 o'clock. Thank you.
Court rise if able.